Hi, good evening. Welcome to the Planning Board meeting of March 11th. I have been just recently informed that our first public hearing is to be continued. Is that correct? Do we have a time and a date?
The next meeting, which would be March 25, so probably we'll have to find a good time. And actually already thought maybe we'd have to start early tonight.
So on the 25th already, you have the public hearing of zoning amendments.
Yeah.
7:30 to 8:30. And then at 8:30, public hearing for Maspinock Woods, and 9 o'clock, public hearing for Whisper Way.
8:30, Maspinock Woods. And what time, Whisper Way?
That starts at 9.
9.
And when's the next meeting after that?
April 8th.
Is there anything on the April 8th meeting?
There's a public hearing, no time set for that one yet?
I was just assuming that we would have 76 Main Street, site plan and discussion permit for the industrial community development, starting at 11:30. But that's the only thing so far for that.
It's a new application.
Just from the board's perspective, can you see us extending the zoning conversation to the 9th as well? Or do you think we'll get it done in an hour?
No.
I don't either.
I guess no.
No.
All right, so we need some time at the 9th for that.
On the 9th or the 8th?
April 9th.
April 8th. Oh, 8.
8, I'm sorry, thank you, I'm sorry. I wrote 8 and it looks like a 9, so that's my, that's my fault. So 7:30 there, say 8:30 for the zoning, and then 9:30 for something. My sense is we're gonna have to put it off to the 8th, what do people think?
I would concur.
Okay, so I'll entertain a motion to continue the public hearing on Bucklin Street and Leonard Street to April 8th at 9.
Second.
And we have to extend the decision. What would be the,
2 weeks following that?
so the decision to say the 24th, 23rd? All those in favor?
Aye.
Any opposed? Any abstentions? Okay. All right. So our next public hearing is not until 8:30, so we have a lot of time. We do have, the nations are here, and they can start earlier. Hold on one second, though. But the other thing I wanted to ask the board about before we jump in, this is all happening on the fly. Katie Towner has asked us to talk about the Wilson Street drainage basin, and we got more information from her just in today, but also Roy McDowell has asked about having that scheduled at a time when he is also able to be here, and that's not tonight. So I don't want you to sit here the whole time if we're gonna move it to a different meeting. What do people think about rescheduling that to a time that Katie is available and Roy is available? Does that make sense?
That's reasonable.
Makes sense to me.
I'd also appreciate a little time to read through this as well, because I haven't looked at it yet, and there's a lot of detail here.
Just introduce it. So I'm okay with you taking 10 minutes to introduce it, but we're not, I think we will schedule talking about it, and we do have plenty of time, so if you wanted, are you gonna stay for the whole meeting or no?
Yeah, I might.
All right, so the nations were told that they could start at 7:30, so we'll have them come forward. I'll save 10 minutes for you to introduce your materials. Is that okay? All right.
Just a process question.
Yes.
So on the last agenda, there was the 495-90 intersection, and it
Yes.
seems to have fallen off.
I have that tentatively for March 25th.
Okay, thank you. Just wanted to make sure you didn't forget about me. Thanks.
Appreciate the question.
Just a question, is it an option to discuss that tonight, or does it need to be on the agenda to discuss it?
Agenda.
Okay.
Okay, so I welcome the nations to come forward. It's not necessarily a public hearing, so they can come forward at any time.
Thank you.
You're welcome.
So I'm here to to run something by you. On Whisper, we've come up with a cul-de-sac plan, and it has 10 lots. And then there would be an A&R plan that would require a common driveway and be 2 lots. So we'd have 1,000 feet of road versus 3,500 feet of road. We'd have 10 lots on the 1,000 feet of road and 2 lots on the common drive. And the original subdivision was 24 lots. So there's a lot of moving parts here as to why we're doing this, but it's the best thing. So I'm hoping that that you could see a way to kind of giving us some direction to move forward, and hopefully I could get back into the definitive process, or however it works out. So I've got.
Is there something we could present, or is it all hard copy?
Yeah, it's all hard.
Okay.
Yeah.
Could it go on the screen?
I could have done
Could it get up on the screen? Does it?
Yeah, they could put the camera on it if we have like an easel or something.
Hold it up.
It's hard to hold it up though.
Have the lovely Vanna White hold it.
On the hardboard?
Elaine, do we have an easel anywhere or no?
It won't stay on an easel, it's soft paper anyway in this case.
They've got cardboard.
I was just thinking we could do, stick it on this and hold it up somewhere. This camera over here.
Oh, thank you.
That camera, right there.
Yeah.
There's a requirement that you smile while you're holding it through like Vanna White.
Are these all the same, or are there various
They're all the same.
interpretations?
Just,
It's all the
just
same.
go,
Right,
just stand over here.
there you go.
And angle it towards
Angle
this
it towards
camera.
that camera. This one.
That way. There you go. There you go.
You can zoom it in.
There you go, you're doing it.
Okay.
You're doing it.
Hold still. Perfect.
Still,
Perfect. Stay right there.
just hold still, you're good.
Don't breathe.
So actually, Ron, I have to have you at the mic so everybody can hear, including the folks at home.
Nice try, you guys.
It's still open with us.
Okay, so,
Sit around so we can see the map on the screen.
sure.
It's, oh, yeah.
Yep.
Okay, so there are 10 lots on the cul-de-sac. That's two of the houses would likely remain of the existing 4 houses. The lots are all in the 1.5 to 2 acre size, although some of the first one, the first 3 coming in are the about 30,000 square feet. The road that comes in from Wood Street is the existing road is, you can see where it actually ends. Well, it doesn't actually end where that knob is on the right-hand side, but but it ends back pretty much right where that big black spot is, which is the parking lot for the parking area for the town forest. Cameron Woods, I believe.
That we parked in.
Real quick question.
Absolutely.
Just, so do the lots all meet all the frontage requirements?
They will.
What is it? Is it 100 feet or 200 feet? 100 feet
I think it's 100,
for open space?
yeah. It might be 125,
Is this
I forget.
residence B or?
I think it's agriculture.
Is this agricultural zone?
Then it'd be 100 feet, yeah.
100 feet. Thanks, Elaine.
So it simplifies the drainage, it simplifies vernal pool impacts, it simplifies just a lot of things, and still allows the property to be developed. And this is a very very rough draft. It's just showing that the lots can fit. The drainage is gonna be relatively easy with this layout. The drainage down to Wood Street has already been pretty much vetted with fill. So we're not concerned about that. So then, and this uses about 29 acres. You know, half of that is open space. So it, you know, it will comply with all, there's plenty of land to make sure the open space ratio works. The septic system, the big black thing down at the bottom, is still a septic area. We won't be using all of it. We'll probably use half of that black area, and the rest would go towards open space. We'll probably use a little less than half of that. So then on the, and the 10 lots will require 2 common driveways to minimize, well, one of them is an existing driveway now. It goes up to Dan Mack, to the house it's already in.
Lot number 9.
Right. So lot 10 would come off of that driveway. And then there's lot 4. Lot 3 has a common drive with lot 5, I believe. It would peel off and pick up lot 5. And that comes through the lot 3, lot 4 lot line. And again, it's pretty preliminary.
Yeah.
Approximately how long are those driveways?
The longest one is about 500 feet.
That would be lot 3.
Yes.
Through the chair.
Yeah, and we could shorten that one up. We probably would shorten that up somewhat. Most of the new lots are outside of buffer zones for wetlands, vernal pools. You know, we comply with most every setback with 1, 2, 3, 4, 5. Yeah, all but 3 lots, which already exist.
So Ron, thank you. So Ron, one of the big issues we have with long cul-de-sacs is a second means of egress for emergency vehicles.
We don't have that.
So that would be something, I mean, normally our limit is 300 feet, I believe, right, for cul-de-sacs?
In an open space subdivision, it's 1,000 feet.
Oh, it is 1,000 feet, okay. So you wouldn't need it, okay.
Can I just ask? Go ahead.
How long is this cul-de-sac? How long is the cul-de-sac?
1,000.
It is
1,000.
Okay.
And then just asking the obvious question, adding a 500-foot driveway, does that,
There's no limit on the length of the driveway.
We would comply with, the fire department has standards for driveways, and we would not have a problem complying with that at all.
Chair, question, would there be sidewalks on that?
Whatever the board desires.
there goes our little nature trail though through the property.
Yeah, well, no. Well, so, all right, so, well, the yeah, we don't have a problem putting a sidewalk on the cul-de-sac. The sidewalk out on Wood Street, that even became more problematic as time went by. It was keeping water out of the wetland. It was going to keep water out of the vernal pool, and you're not supposed to add or subtract a drop to the vernal pool. So, and it was to connect, to make a loop. And I know it's in the special permit, but we do no longer need the waiver for the 100-foot. We can comply with the 100-foot all the way around, unless, you know, we're up to the town property coming in on Whisper, the existing road. So I would run that by the board, that maybe we could not build a sidewalk out on Wood Street.
Question from this far side.
Yep, go ahead.
Mr. Nation, the 5.8 acre lot and the 4.9 acre lot are now being left out of this?
Yes.
And the current house then, it's on the 4.9 acre lot staying?
I think the current house would probably be raised at some point. So that's where I'd like to do the two A&R lots. There's a lot of frontage out on Wood Street. There's an existing road, a driveway to that area, and it's actually the original Wood Street.
Yeah,
And,
which is amazing.
yeah. So, and then that goes up to 129 Wood Street, and behind it is a farmer's cart path, which exists. It's got a 16-foot long pipe, and then they built a stone road over it. So I'd like to go to Concom and see if we can get a common drive over that.
And does that also,
And
it takes away the turnaround parking area for the horse trailers?
it does.
That's the current parking area? But there's originally...
There was gonna be one with the loop over on the other side.
Right.
But does this,
I did talk to Jane Moran about it, and we haven't given up on the trailer parking area. We possibly could do it in the same spot. It just becomes a little problematic with it being a common drive, somebody's lot. And then up on the cul-de-sac, there really doesn't seem to be a good spot for it. That although the land to the right of Whisper is a CR, they don't want to make the parking lot any bigger, from what I understand from Halt. And then the other spots would be to put it, park them in front of people's houses. So I've got to look into where we were going to put it initially and try and make that work.
and you said the 4 houses, did you already start building some houses, or these are the 4 that are there already?
No, there are 4 existing houses now. One's on the old Wood Street, and then the other 3 are off of Whisper.
Thank you.
Mine is just a comment more than anything. I like this plan in theory. I would like it a lot better if Lot 3 was not a building lot.
If lot what was?
Lot 3 was not a building lot. I think that's an incredibly long driveway. And perhaps you could use a part of that to expand the parking for the open space and connect through that skinny peninsula that's connecting to Whisper Way.
Well, so lot 3 is, we don't plan to do anything in that wet area. We would stay out of that, and that was just the frontage, and that was one of the reasons for the common drive. Though we can reconfigure that area so that there's upland for a driveway on that lot. We just thought that it would be better to use a common drive. Quite frankly, the numbers don't work if we eliminate a lot. It's just a lot of road for a small number of lots.
Essentially half the number of houses, is that right? Is that what was the first plan?
24.
24.
Through the chair, I'd just like to add on to what Carol was saying, because I don't like the idea of houses behind houses. It's not a good layout.
I live in a house behind a house, just letting you know, and I love it, but
Just a personal opinion for new development.
Well, these houses are spaced. I mean, there might be you can turn these houses any way you want. There's all kinds of room out there. It's gonna feel like big sky country out there.
I believe that's true. 500 feet, though, is a long way for a driveway.
It is. It'd be expensive to plow and maintain, and no question.
and I can assert to that too.
Through the chair, 2 questions for you, Mr. Nation. One, I'm wondering if you could just clarify again, how much land would be put in conservation as part of the open space subdivision? I'm trying to remember how big the original acreage is, and I'm just curious.
Well, the original acreage was 47, I believe.
47, and how much of it would you be putting into buildable lots on this plan?
This one is 29 acres total. Half of that, 15 is
19-ish acres.
is open space. So
And
15
of
acres,
Of that 15 or 19 acres of open space, do you know how much, or roughly how much of that is wetland?
2.
Just 2 acres?
Yeah.
2 acres of green.
You can see it here on
In
this.
this green shaded.
Okay. And then my second question for you, I realize this is just preliminary, but I'm curious if you have any thoughts on, at least initially, what waivers you would be requesting with this proposal?
trying to find that,
To build on these 2 parcels.
It's so easy to, I'm going this way.
I don't think there are any additional waivers. We can get rid of one waiver, which was the 100-foot.
100-foot what?
The 100-foot setback for the,
Buffer.
100 foot of open space around the perimeter.
Again, except for except for the entranceway, the existing Whisper Way, right?
Sorry, what was that?
Except for the roadway, the existing Whisper Way, right? It would still be the buffer.
Yes.
He was
Yep.
also asking for sidewalks on
He didn't
Wood
say
Street.
that. Oh, on Wood
He
Street.
did ask.
But I think without the
The loop, right?
loop, there's
Not
That's an
necessary.
issue.
no requirement to put a sidewalk there.
So the perimeter buffer, I don't think we need anything on that, a waiver for that. The detention ponds and open space, that's probably, there might be one. There might be one remaining, and before there were 3, I believe. And we can make all those areas work. There's not supposed to be more than 10% of the, or maybe it's even less, of the open space, retention. That's it.
So the rest of the waivers stay the same?
I think maybe, I don't think we'll need any.
Oh, okay. Just the lighting, but we don't want you to necessarily light it anyway, right? Amy, do you have a question?
Oh, so the 10 lots will be on the cul-de-sac. Can you point out where the other 2 would be?
Right off of Wood Street.
So this is the old Wood Street, the driveway to 129. And so you get up there and the road ends. There's a chain link fence up there. And then behind is the farmer's cart path is right here. So we'd go out here, and there'd be a driveway here and a driveway here for these 2 lots. There's another piece of land back here, and we'd probably just combine them on the line down the middle or do whatever, but they'd just be large lots.
Muriel?
Yes.
They would be long driveways as well.
I'm sorry, 1 second.
Okay.
Approximately how long?
From the road?
8,000.
Long driveways.
My question had to do with the common septic. Are those 2 extra lots, are they on the common septic with the other 10?
I think that we'll be able to get those on their own.
Okay, on their own.
And we'll get 2 or 3 of these on their own too, maybe more. If we can get them all on their own lot, then we will.
Okay. Oh, so you might not even have the common system.
That's the goal.
Okay.
Well, it's,
Right.
Any other questions or thoughts?
I just have one more comment. I'd echo what Carol said earlier, that Lot 3, and again, I'd have to go back and review it in more detail, but the idea of a 500-foot driveway sandwiched between two lots with 100 feet of frontage, just,
And then the two approximately 1,000-foot driveways?
yeah, I mean, like I said, I don't know what's within our bylaws and what's not there, but I'm not crazy about that, just my opinion.
The fire chief is here, but this is so preliminary. I might recommend that you definitely meet with the fire chief
Sure.
before you get too far
Yep.
down the path, so that you have a really solid idea of how he feels on the
Okay.
safety.
I might add a different view. I have faith that, especially working with Craig on the Conservation Commission, they're really good at moving things around. This is just preliminary, and then with our feedback and meeting with the chief, I'm sure they'll work out something that fits. They're really good at it.
Thanks.
Wanted to
Yes.
also mention that the common driveway on the A&R plan requires a special permit from the planning board, so they'd be coming to you for the special permit.
Okay. That's the one that's the real long one over there? Okay. Anything else, Elaine? I should have started with you.
But not that one, because it's existing. It'd be nice if that,
Just as one last suggestion, and I don't know whether it would work, but it might make sense rather than having two off the can you do three off a common driveway?
Only two. Only two.
Okay.
Through the chair.
So, I'm sorry, where are you looking, Carol? Just because I'm not...
It doesn't matter.
Okay.
Doesn't matter.
Around lot 9, why you didn't come up with the driveway straight to the street? Is there a reason?
It's very steep.
Okay, the grade of the land?
Yeah. And the existing driveway can be modified to make it, to
Just curious.
comply with the
Just
with the
curious,
regs.
thank you.
And the 1,000-foot driveway might be only 800 feet or so. But we'll science that out a little better.
So my own feedback is a beautiful piece of property, and I'm sure there'll be amazing houses and so forth in there. So if it's possible, I mean, obviously, I think we're all concerned about the length of the driveways, and we don't particularly want a bunch of runways coming out onto Wood Street. You know what I mean? It's a little bit of a balancing act, but I'm sure it would be beautiful done. It's just a matter of whether it can.
Yeah, it's gonna be a whole lot different from what we had planned, and what was, to me, it was death by 1,000 cuts, you know, the detention basins got higher and bigger, and everything just got moved around. The emergency road didn't have any houses on it, but, you know, it needed this 30-foot culvert and retaining walls, and then we had to start running water backwards or uphill, if you want to call it that. But so you had to build the road up and then get the water in the road and send it that way. And it was just
Yep. Challenging. So will you go back to Concom, or are you good with them because this is
we're going to go tomorrow night and just
tomorrow night?
run this by them.
Okay. Okay.
I think they're going to like it.
Yeah, I
There's a lot less impacts.
feel like, yeah, it seems like it'd be preferable for them. And I'm interested to hear, and I appreciate that you're still keeping the idea of the horse trailer parking alive if it's possible, because that was a pretty nifty value add there.
Yeah. I'm focusing on the only place I believe is on the old Wood Street, same place. So I've just got to, I think it can work.
Good.
Okay.
Here we go.
Thanks for your input. Appreciate it.
Good luck.
Yeah, thanks.
Ron.
All right, Katie, you want to do your 10 minutes?
What process question, sorry?
Thank you, sir.
Yeah.
We need Ron for the exception of the streets.
We have to keep one of those.
It's his two developments, right?
We have to keep one of those.
We might. I don't know, do we need the nations for the street acceptance discussion? Are they staying
Maybe
for
needs
that?
not the right question.
Yeah, probably good. They can stay if they want.
I sent a late email, I don't think Elaine saw it. You could present photos? Or we just,
Okay, Katie, take us through the intro.
So the comments I had were for the, after this bioretention basin to solve the Wilson Street drainage problem was approved by the board. It never materialized. It was supposed to be built, in November or whatever for winter, but it never materialized, so I put in an official request for all the correspondence and memos for the why, nothing had happened, and that's when I saw this change order had been put in after the plan had been approved. A change order was put in to essentially remove the layer of bioretention soil from the structure. So what's most disturbing about that is that this structure, which has been tried to be put forth and accepted 4 different times in unsuitable designs, this structure is supposed to capture the pollutants and the solids, the runoff from, the whole Legacy Farms Road, and then the, what's also coming down from Heritage Properties, which we've documented over the last year. We've documented many pictures how that whole area does not drain properly, and there's a stream running through, and the silt runs down Legacy and down Wilson and whatever. So during the hearing for Heritage Properties, we tried to ask all the right questions. We asked if there was pesticides present in reportable levels on this property. I asked, other people asked, we all asked at the hearing, and we were told, we directly asked Roy McDowell, and he told us it was a matter of public record and that we could go find it for ourselves, which I did. It took me a while, but I did. I found the memo that documents all the testing that was done and the reportable levels and what is supposed to, because they qualify for an exemption, it's not an MCP site, they don't have to clean it up, but that soil is supposed to stay in place on that property. So I'm rather disturbed and also I found out that this memo was in the hands of the town of Hopkinton. So, I'm a little disturbed that when we asked for it, it was not forthcoming. And clearly, many people were aware of it. And I think it should have been part of the hearing, just to make sure that the structures were adequate to contain the runoff. The importance of containing the runoff, just one, I'm not a chemist, but one simple detail about and these are banned chemicals. This is dieldrin and DDT. So these chemicals have been banned. They're bad, okay? But their chemical property is such that they bond to soil, okay? They bond to the soil. So when you have runoff, it's in the soil, right? And the only way to make sure that it doesn't go through our municipal stormwater system, which is Hopkinton, is to have a physical barrier. And that's what this bioretention soil is. And that's why it's expensive, because it's not just dirt. It's an engineered soil. It's very fine-grained, and it's mixed with different particles, clay particles. So the clay is helpful for the oil and grease and stuff that's typical on the road. But the fine grain of the sand prevents the runoff particles from going through it traps them. It's a physical barrier to trap that runoff. So, I mean, I didn't know any of this stuff. I had to request all these documents, and I had to spend several weekends reading them all. And, this is not right. This is not right. And many of us asked about this at the hearing, and I don't think we got the hearing that we should have. I think that, when people get up to speak, I think there should be questions from the board. I don't think we should get blank stares. I think you should engage with us. I know we're not experts, and maybe we don't use all the right words, but, we are trying to contribute to making sure that we do the best, get all the information out there. What this represents is that the structure, removing this layer of bioretention soil, degrades this structure such that it cannot perform its function, and that function also includes the capture, the trapping of the runoff so that the DDT doesn't migrate. And because it is a part of the Hopkinton municipal stormwater system, it's our last line of defense, and the town is liable. I kept my summary here brief because I wanted to stay to the point of this particular basin and why I would like the design to go forward with the full layer of soil. But there are many other things happening related to this that I guess I can get into further detail next time if we're going to do it again. But what's happened is all of this contaminated soil has now been scraped and piled up into a mountain because that's how they do construction. They scrape up this soil. But eventually it's got to be, distributed back out on the property because it can't leave the property, right? That's the rule. And right now there's a silt fence around it, although I drove by it tonight and the silt fence is knocked down. I sent you pictures of that. So, there's a lot of concerns about, about building proper structures for the purpose they're intended and taking into account the fact that this property has special issues and they should be dealt with. So, I guess that's pretty much it. When I was very disturbed when I read through the documentation that I got saying it had gone through like several hands of people doing drawings and buying materials and everything, and with each successive person and email that the design went through, it got more. It was like a game of telephone. It got more. The intent of the structure got more, misunderstood. And then it came back with, well, this structure is just meant to hold a whole lot of water. And there's really no water quality issue that has to be dealt with, right? So the bioretention soil is kind of like, why do we even need it? Because the whole purpose of this, that's how it came down to the final, like, when it went through 5 drafters and people, is that, oh, well, it's not a water quality issue. Well, it is a water quality issue. It's a water quality issue for, for everything that's coming down the road. It's a water quality issue for all the runoff that's coming off the whole property. And plus the fact that there are other, there was a mudslide off the other end of the property that still hasn't been properly, they still haven't done the testing. They were ordered to do testing of that mudslide back in November, and they still haven't done it. They still haven't done it.
Is that the piece of property that's closer to the gas company, to LNG?
No, it's went right into the reservoir. It's the back end of Heritage Properties, and the mudslide went right into the reservoir, and there were several violations. All the fines were obeyed out of goodwill of the board, And they asked them to do the testing, and they never did it, right? So, you know, I've been going back and forth with them, saying, well, if they're, you know, if someone ordered me to test, I would do it, you know?
Okay, Katie, I'm going to
So-
stop you there. We have a couple questions.
Well, just as a point of clarification, I think this is very worth discussing, but I'd like to discuss it where it makes sense. So I would just like to know, can you clarify for me why you think they're eliminating the bioretention soil? Because the letter that I'm looking at from Wayne Amico to Georgia says that they're making it deeper and smaller, like less big around, but that the bioretention, the way I'm reading it, is the bioretention soils are still going to be there. So
It's not, it's supposed to cover the whole bottom of the basin, and making it a half a foot deeper is, you know, it's not supposed to be a pool. That's not, this is something that, it's not a pool, it's not a pond.
I don't want to get into the nitty-gritty of it. I just want to know the bioretention soils, from what I'm reading, are still there. Are you saying they're inadequate or they're being removed?
I'm saying that the degree to which they you know, they just left a small square of bioretention soil just for show, I guess, and so it has made the entire structure non-functional. You know, I mean, that is what makes the whole thing work, is that whole layer of bioretention soil.
Okay,
You know, if it's,
thank you. That'll give me plenty to think of before
you know, I mean,
we
it's,
talk about it.
it's hard to think of soil as an engine, but that's what it is. It's the engine that drives that cleanup thing.
Katie, I had a couple questions. One, you talked about the change order
Yeah.
that was put in. Who put the change order in? Do you know what date that change order was put in, and why that change order was put in? And was that change order then subsequently approved by the town? Do you know any of those?
Yeah, because I did a FOIA request for all the documents, so I have all those documents. I can.
So maybe at the
send-
next meeting, or even beforehand, be able to kind of
Yeah.
show that, because that shows to me to some degree the intent, or the idea of there's intent, why they actually put it. There must have been a reason why
It was
somebody.
cost. They said it was cost. They
Great.
did.
That's
They didn't
helpful.
want to pay. And I said in my memo, it certainly is a cost driver. It's an engineered soil, that, of course, it's a cost driver. And for any developer to say they, you know, were blindsided by that is kind of absurd, because
So
they got to know that.
I think it might be on page 38.
Is it on there?
They got to know that, you know, obviously it's a cost driver. But it's also a cost driver for the town if you, you know, and you're liable. In the other things that have been going on, there's an open case with the EPA about that mudslide into the Hopkinton Reservoir. And, you know, many memos went back and forth, and the question was asked, you know, is the town liable for this stuff moving off the site? And the answer was everybody is. Everybody who's involved in this is liable if this stuff migrates off the site, you know? Everybody.
Through the chair, please.
Yeah.
Katie, thank you for coming today. A couple of pieces of advice. I agree with you on a lot of what you're saying, but this letter perfectly states what you're talking about, but you got so far afield from it that I was like, I had to read it, and we just got it today. And if you just read the letter tonight, then great, I would understand exactly what you were saying a lot earlier. But you had to get this to us at least the week before, like the Wednesday or Thursday before, I believe is a cutoff date, so we can have time to read it, because we put hours in reading all the documents we get and going over everything. And so I think this is very helpful, and Fran's questions were very on point. Thank you. I'd like to know if Elaine maybe knows some of the answers already, or some that needs some more looking into.
I think it'd be helpful to have the owner here.
Yeah. The other thing is that if there's testing that needs to be done, let's make sure we communicate that needs to happen.
Conservation Commission that's managing
Doing
that.
that? Okay.
And then one last point. I'm a little bit unclear of where the Legacy Farms mudslide could have gone onto that didn't have to go through Ashland's portion of property
Did.
to get to the lake. Did go through Ashland. Because they have a rutting problem on the side of the road anyways, probably from runoff from our side, but
It was a big mudslide. There was no gray area there.
and to be clear, that's Ashland's public water, not Hopkinton public water, although we do get water from them. That's a whole other thing.
Everybody was involved, Hopkinton, Ashland, the state. It was a big deal.
And when was the mudslide?
Thanks, Donna.
When was the mudslide this recently?
It was October, November.
Yeah, they came in.
And they were, the concern was because, this soil is contaminated, and concern was go test it, and it still hasn't been done, so.
Amy has a question.
I do too.
Okay.
I'm wondering if it would be appropriate to get comments from Beta on the change that was made in November before our next meeting?
It's possible.
Can't hear you.
Okay, I'm wondering if it would be appropriate to get comments from the Beta group before our next meeting about the change that was made in November?
I think it would also be appropriate for them to comment on the containing the DDT in the dieldrin, that why that never came up in the public hearing and is never part of any of the design.
Okay.
It should have.
We got it, for sure. Mary?
Okay, my question was for Elaine as well, and that is, if we can have for the next, for when this is discussed, if we can have not only the revised design modification that is referenced and I believe attached, so the one dated November 28th, but also the previous redesign of Basin 8 that was approved by the planning board prior to this administrative change. So we can do the direct comparison. I think we only have one set of those plans here. Okay, that would be great. Thank you.
Katie, can I ask you one quick question, and then we're going to have to move on? Did you, are you taking this to the Concom where they are responsible for the testing?
You mean that other issue?
Yeah, I talked to them. I talked to them several times, and I talked to them again today, and they still haven't. They wrote them a very detailed memo about what they wanted them to do, and that was back in November.
Concom wrote a very detailed memo. Okay.
Yeah, and there was no response, and then they wrote them another letter, and then there was a kind of a half response, and they still haven't done what they were asked to do, so I asked them to put it on the agenda again for discussion because, I think that they gave them the full benefit of the doubt for this.
Do you know if they have put it, are going to put it back on the agenda? Have you
He
heard?
said he would put it on, like their discussion items, or they have another thing they call a report or something.
Elaine, when did Mr. McDowell say he would be available?
In 2 weeks.
In 2 weeks.
Piggyback on that, are there any other players that should be invited other than Mr. McDowell to be able to explain? That would be helpful. Maybe.
And we talked about 2 weeks being very tight, didn't we?
Mm-hmm.
Well, there's no rush. We're going on for 4 years. It's not like you could do it after you're, but then they can't build the basin, right? I don't know. Probably can't build it anyway.
I do know that Phil Paradis will not be here on March 25th.
Oh, okay. Okay, so we might definitely put it out to the 8th then. We do know that we have a public hearing on the 8th. We just haven't, on April 8th, 76 Main Street.
And Bucklin and Leonard.
In Bucklin and Leonard at 9.
And
Possibly zoning.
Zoning at 8:30, just jotting. I guess 9:30. that doesn't necessarily need a time, right? So if we had cancellations, it's something we could do at any time. So let's try and communicate that to all the folks. So on the 8th, we have... April 8th, we have a public hearing for 76 Main Street. If for some reason that was requested to continue, as that spot would open up. We have zoning, and I'm quite sure we're going to need that time, but then we also have Bucklin at 9. So it's possible that we could deal with it more substantially and earlier, just letting you know that it doesn't have a particular time to start. We're putting it on at 9:30, but it could be discussed at any time at the meeting.
Yeah, I mean, as long as they don't go and build it before we get to talk about it, but I think that's probably unlikely. Yeah.
Okay, thank you, Katie.
One more thing.
Yeah.
Fran's point earlier about who else maybe, could we have the
Oh.
chair of the Conservation Commission or someone from the Conservation Commission that would speak directly about the conversations they've had about this issue?
We can invite them.
Invite you.
Right?
Thank you.
I'm kind of, who from the state is overseeing? Do you know, Elaine, who from the state is involved in that oversight? Of the slide issue, do you know?
DEP.
It is the DEP? Mhm. Oh, I love the DEP. It's like their biggest fan. Okay, all right. Well, that's interesting. Thank you, Katie. I appreciate it. All right. Do we have, I don't know how to do my pages again. You have to help me, Amy.
TJ Solar.
That's at 8:30, right? Do we have anything that we can do?
With your approval not required?
Oh, the A&Rs? Yep. Oh, perfect. Do we have the applicant for Main Street A&R?
92.
I'm busy trying to find my agenda. I apologize. There it is. Boom. Here we go. Welcome, Mr. Duffy.
Thank you. I'm trying to get something straightened out that should have been done in 1995.
We have heard that a lot for some reason. People have got to trot to the Registry of Deeds. That's all I'm saying. Go ahead, sir.
I live at 92 Main Street, right at the top of the hill there. The White House with all the flowers. And, thank you. And the Evergreen moved in next door to us. I did a land swap with them because they wanted, when they built on over there, part of their bulkhead was going to be on my property, so we did a land swap. They said they were going to have it all recorded and everything done. I went, never got recorded, so I'm doing it myself now.
Okay, so the land swap has taken place, and they should have recorded the deed, but you're gonna do it for your own purposes because it wasn't done.
I'm in my 70s. I don't want it on my conscience. I want to get it off my hair. When I put my garage on in 2015, I knew about this then. I spoke to them. They said they were going to take care of it, which they never did. I put my arbor on, which I'm going for a special permit on up there. Make a long story short, that's when all this developed. So I've spent almost $1,700 so far.
Okay. Anybody have any questions?
I have one question
Yep.
for the applicant, Mr. Duffy. Is the other party, were they available to come tonight to explain?
They've
why
been ignoring me like the plague.
They gone crickets, huh?
You know, when money's involved, they don't want to talk, apparently, you know?
But this is entitled to approval, right? Even though the other party is not here. It's been endorsed before. Okay.
Okay. All right. Is anybody willing to make a motion to endorse the A&R plan as presented?
I would make a motion.
Is there a second?
Second.
It's Amy and Deb. Any further discussion?
Yes.
Yeah, go ahead.
Pardon me for being a little bit behind the curve on this. Usually, we like to have both sides work things out, and this acceptance, to be clear, is a one and done, and then it is what it is. So, you're happy with it?
Well, I don't have a problem doing the land swap at all. The problem is that I want it to be recorded the way it should be.
This, unless I'm misunderstanding, this was one and done in 1995.
That's correct.
It's
This
been
is
all done,
correct.
this is just a record-keeping,
That's correct.
record-keeping issue.
Yeah, to record it with the deeds. I'm comfortable. Anything else?
If you're happy, I'm happy.
All those in favor signify by saying aye. Aye. Any opposed? Any abstentions?
Abstain, because I wasn't present.
All right. Do we need to sign, or?
So now we're at the end of the meeting with the other
I might as well do it now,
We
right?
don't know,
and then he
you don't
can
want to wait. How many signatures do we need?
Photo two? Look at you jumping up.
I can stretch out my legs.
I'll sign.
It was the property downstairs, but then he's.
They came to the planning board and said they want to stamp this property. It doesn't change.
Thank you.
I was trying to figure out where this is.
What to do is for
Yeah, okay, yeah, I know that, the hair salon, yeah. Well, there's, this patio has like trellis around it.
Out of gear?
It's like a trellis here and.
I think it's around here that he's going up the line to this.
Oh, okay, yeah.
I have nothing to do with it, tell my wife.
Now, this is the way you take down to the senior center?
Yep.
Oh, okay, got it.
That's into the
Yeah.
Going by height
it is
today.
painful. And where are you going tomorrow?
My attorney's going.
All right.
Oh, I thought we were playing basketball.
I don't want to see you back here in 2030.
A long process. Thanks so much.
All right, good luck.
Take care, sir. All right, do we have anything else that's super quick? Minutes.
Want to do this, is there minutes?
Potentially, we don't have minutes.
Do you want to do the quick street acceptance
I
real
was
quick?
like, yeah, I don't remember reading minutes.
Is
Just
there,
has a couple photographs I want to show, but that would be real quick.
okay, well, if it can be quick, you have
Elaine, would you be able to pop up those photographs real quick for the street acceptance?
2 minutes.
Can do it. If I may?
Yeah.
So, guys, Frank. So we're just gonna, we have an agenda item further down, the street acceptance, and the two on there are Ron Nation's, Hunter Ridge and Penny Meadow Lane. And these are photos that I took a year ago from last month. And when the street acceptance came up, I just noticed that I still have them on my phone. So I just wanted to make a comment about LID development, which is low impact development. So, we talked about this in the past, how, it's not really a clean edge, and there's advantages and disadvantages, but I just wanted to show the folks the pictures I took from there, because to me, if I was moving into a new development, I'd probably want a cleaner line, but that's just my opinion, with a curb there. And this is just on the corner, and I think there's just 3 photos, so. Okay. I just wanted the visual. I mean, I'm going to approve the street acceptance anyway. I mean, that's how we, not me, but personally, but we as a board approved it, so. Let's give it a little 3-minute filler
Yep.
picture session.
This is what you aren't so crazy about.
Correct.
Yep.
Yeah, sorry, I didn't spell that out specifically.
Yeah,
but
no.
I didn't want to apply too
No.
much opinion to it.
No, yeah, no, I appreciate it.
Do we need a quick vote on the street acceptance?
Well, we do need a vote on the street acceptances. Is there any other, are there any open issues? As I was reading through it,
There are a couple of minor issues that would have to be addressed before that.
okay. What about the pavement? Is that one, the pavement that's encroaching on a lot, is that one resolved?
DPW discussed it with the developer, and they will address that.
They will address it
For that.
before town meeting.
We have a
Anybody-
cooperative developer.
Cooperative developer? Does anybody have, oh, go ahead, I'm sorry.
DPW is waiting to do their final inspection after the snow cover is gone.
So,
Days. 2 days, right?
So if we vote to approve it, that has to be done, or does it have to be included in the vote?
It has to be done regardless.
Okay, all right. So if anybody's willing to make a motion on the 2 street acceptances,
So moved.
to accept them,
Accept them.
all right, is there a second?
Second.
So that's
Yep.
you're accepting the street acceptance report to be forwarded to the Board of Selectmen.
Yes.
Ultimately, that accepts.
Thank you.
Okay.
Okay. So we're really endorsing the report to go to the selectmen for town meeting consideration.
That's why I'd like to change my motion to exactly what she said.
What she said. Is there a second?
That's what I was seconding.
Now that it's cleaned up, Frank says, now I'll second it. Any further discussion? All those in favor signify by saying aye. Aye. Any opposed? Any abstentions? Okay, look at us go. All right. So I will entertain a motion to open the public hearing for the special permit application for the commercial solar photovoltaic installation, Wilson Street, Cedar Street, TGA Solar.
So moved. Second.
All those in favor?
Aye.
Any opposed? Any abstentions? Okay. Come on down. Welcome.
Good evening. How you doing?
So, just for the record and for the public's information and for the board, we have 2 members. It's hard for me to believe that I can't be heard, but I appreciate that. We have 2 members, I believe, that cannot vote, and that's Carol and Frank. But
I thought because this is a remanding that we can't.
Are you wagging your finger at me? I'm just asking.
Not in this.
I think that we are just reconsidering it. There's no new material, and I think that the voting status stays the same. Is that right, Elaine?
The voting status stays the same unless they want to go through a presentation of the entire record, I think is the way it works.
I believe the order, what was requested and what was ordered requires us to incorporate the prior hearings, which then excludes the members that missed more than 1 hearing.
Okay.
So I don't think there's really an option.
Okay, that's,
In our memo, it does say Frank is eligible.
yeah, that's incorrect.
mistake.
Yeah.
Yeah, there's a comment from the public.
Hold on a second.
But
In the,
also, Ray did say that I could. I mean, I specifically asked him.
I remember that.
On the remanding, though. That's,
The hearing that Ms. that was
They started over. They talked about different options. They started over.
so, but to be clear, any member here and present can interact with the conversation.
Sure.
Yeah, it's just not the voting. It's not time for public comment yet, Mr. Cutter. You may always ask a procedural question, but only if you come forward to the mic and introduce yourself.
My name is Edward Cutter. I live at 21 Wilson Street.
You actually, truly, you have to be here to do that. Go ahead and, just because the folks at home can't hear you if you're not up here when you start.
My name is Edward Cutter. I live at 21 Wilson Street. I'm in a butter. I happen to notice there's an order of remand in this case from the court, and the order of remand from the court says that the applicant may submit to the board a petition, and it refers to that later as the remand petition. Remand petition is mentioned about 6 times in this legal document. I haven't seen a remand petition, and I've been looking for it. I think the remand petition I'm no expert at this, it's going to be obvious, but that the remand petition is really what initiates the whole proceeding, and to me would be like a declaration, a complaint, where you state what you're looking for, what your remedies are, and what you expect. And I know for tonight I've been trying to think of how to prepare, but I don't know if I'm a criminal, I don't know what crime I've been charged with, so I don't know how to respond. So if somebody could tell me, is there a remand petition that we have?
I have a copy of what was submitted, I can give them.
And when was that submitted, please? Tonight.
Yes.
I had thought that in prior meetings of the planning board, thank you, in prior meetings of the planning board, there were some rules set forth as to how much notice and when notices should be, when submissions should be submitted before the hearing. This is to give the board a fair opportunity to review it, and also to give persons in the public, such as myself, a chance to respond to it.
Okay, Mr. Cutter, you've made your point. Thank you very much.
Thank you.
When, have we seen that?
It just was submitted now.
So we haven't seen it. But
There's nothing substantive.
It's a formality.
Is it one for each of us? Okay. Okay, I'm gonna share them.
okay.
So give us a couple of minutes.
Share, pass it down.
Oh, sorry, I forgot we were sharing.
We're sharing.
This is a public hearing, is there information available to the public to see what the board is concerned? One copy for...
If you just give us a minute.
You know what, let me read it, just in the interest of the public understanding. So it is apparently a procedural point. It's a remand petition from TGJA Clean Solar LLC, TGA Solar LLC, versus Francis Durso, David Paul, Amy Ritterbush, Muriel Kramer, Fran DeYoung, Mary Larson Marlowe, Deborah Feinbrug, Gary Trendell, and Carol DeVer as members of the Hopkinton Planning Board defendants. To the Hopkinton Planning Board, pursuant to the order of remand entered in the above-mentioned case by Judge Roberts on January 29th, 2019, the plaintiff TJA, I apparently cannot say that, Clean Energy LLC, TJA Solar LLC, hereinafter TJA or plaintiff, hereby petitions the defendants, Town of Hopkinton Planning Board, and its above-named members, collectively the defendants, to conduct a public hearing with notice and publication as required by General Law, Chapter 40A, on TJA's request for a special permit for solar photovoltaic facility at 17, 0 and 0 Wilson Street and 0 Cedar Street in Hopkinton, Massachusetts, respectfully submitted by the plaintiff, signed by Joseph M. Pasella, Esquire. Okay, so that's what the document says.
I would have expected that there should be something in there that would indicate what the facts were, what relief was requested, the same as when this whole proceeding started. There were site plans and other things.
So
I don't know if they're asking for 1,000 more solar panels. I hope he's going to say no.
So, Mr. Cutter,
Yeah.
I'm going to actually remind you that you're going to have to take your seat, and we will go forward from here. This is, so
paperwork?
I may have started this off inelegantly.
That's his paperwork, thanks.
This is the result of a decision that the planning board made, and the applicant's appeal of that decision in the court system, which is the process. That's the only way that an applicant can appeal a decision. And in fact, it was a joint request from the planning board and the applicant to remand it, ask the judge to remand it so that we could reconsider it. To the best of my knowledge, what I've been told is there will be no new information, or has been no new information submitted. We are really reconsidering the original decision in conversation, just so everybody understands. And I apologize that I started that off inelegantly. Elaine, this is something that we probably should have had before now, or it's just administrative?
It's administrative.
Okay. We're going to get started, and then we will absolutely take public comment. Okay?
Madam Chairwoman?
Yes.
Can you just, for everyone here, can you just quickly walk through what our process is going to be tonight? Because, I mean, normally we would have an outline that we would follow.
Yes.
And I think it would be helpful for everybody to know how this review will proceed.
So I would consider the applicant's comments first. It's a little unusual, and I don't know that we have an established process, so I welcome the board's help on that, right? So I'm going to just start with my understanding, and then if other people have different understandings, this is an open conversation. Our decision read very much like an approval in process, and did not necessarily have findings of fact that are necessary in a decision, particularly if it's a decision that's being denied, an application that's being denied. And so it would have been challenging, it didn't appear clear to all parties, the applicant and the town's attorney, how the appeal would be pursued or defended. And so, on the advice of town council, we have asked for an opportunity to do a better job, specifically walking through the findings of fact that are required for this special permit. Is that your understanding, or in layman's terms, your understanding to the attorney?
So my understanding is that the prior decision was not sustainable, therefore both parties asked for it to be annulled, so that we can have a further hearing on it. And the reason is both the lack of findings of fact on the record and in the decision, and the basis of those findings not being required in the bylaw, some of those findings.
Anybody else want to add their thoughts to clarify what we're doing here?
I'm just a little concerned with the statement he said annulled.
Yeah, I didn't hear any annulled when we talked about it, but I don't know legally what the terms are for this to come back to us, to be honest with you.
It's in the joint motion to remand.
Okay.
So, and just one more comment, if we could clarify, there were no findings that we issued, correct?
Right, we didn't.
So then, to your comment, it wasn't that the findings weren't sufficient, it's that they're
Well, they were, yeah.
Technically, they're not sufficient because they weren't there.
Right. So, since this is new territory for us, what we are hoping to do is have a very clear decision that the public understands, that the applicant understands, and that the board understands. And it is my feeling that you are prepared to do a short presentation. We will absolutely have public comment, but we'll start with the presentation by the applicant, and then questions and comments from the board, and then public comment, and then we'll have to walk through the decision pieces that we didn't do the last time.
Point of order. I have a question and a comment, if I may.
You may.
For Ms. Elaine. General Law, Chapter 40A, is that the open meeting bylaw? Open meeting law?
It's the zoning act.
Okay. And then, when you say this is just paperwork, this paperwork is covered by the fact, an open meeting law, we're having this meeting, it's been posted last week, and this is just part of that process. So it's not, there's no information on this form as it's been read by Muriel that's anywhere adding or detracting from the conversation. It's just process of paperwork for legal reasons.
It repeats what's in the order of remand.
Thank you.
I have one comment, Madam
Yep.
Chair.
Yep.
Just for the applicant, Chris, when you talk, just go through again where you're looking for particular waivers, and just be able to walk through those individually. I'm sure you're probably going to do that already, but that's very helpful for us to kind of remember.
Sure, absolutely. Thank you. So just for people who weren't aware of this, I'm just going to go through the procedural history just shortly.
Okay.
This matter came to a public hearing last on October. It was filed.
When we have people in the audience that can't hear, can we ask for these microphones be turned down?
They're
or
on.
speak closer to them?
Microphones are for HCAM, not for the audience.
For the audience.
I can speak up.
Okay, that'd be great.
Sure. So this application was filed March 9th, 2018 by TJ Solar concerning the subject property for 17, 0 and 0 Wilson Street and 0 Cedar Street in the town of Hopkinton. There were multiple hearings held June 11th, July 9th, August 27th, and October 1st of last year, 2018. which resulted in a significant amount of information being provided, as well as many changes being made to the plan. The application was augmented and accompanied by a number of different items that are referenced in the record, and there's a packet that's been circulated that was available to the public, which we would consider part of the record of this hearing as well. There was, which included testimony from a designated member of the tribes that participated in an extensive exercise to preserve and deal with ceremonial stones that had been identified through a trespass that occurred on the subject property. This case resulted in a hearing in which there was a denial issued. It was appealed to the land court, and ultimately the parties agreed and filed a joint motion to remand to bring it back before the planning board, and we represented to the court that this would be in good faith because the belief was that this could be truly reconsidered for an approval. And so we are here asking the board to reconsider its decision, keeping in mind that the zoning bylaws, section 210, 203 for the approval criteria, and section 210, 223 for special permits, specifically deals with certain issues such as allowing cutting of trees reasonable for construction. It does not prohibit the cutting of trees. It provides for specific language for waivers with respect to buffers. It requires specifically that certain issues are dealt with, and I would turn it over to Chris King, who did the engineering on this, to elaborate on what's been done in the past.
And I'm sorry, I didn't catch his name. Did he state it at the beginning?
My name's Joseph M.
So
Pacella.
I'm going to say it one time. I'm not going to have people shouting from the audience.
All right. Madam Chair.
I'm just not.
I just didn't hear his name.
Yep. Go ahead and repeat your name, sir, but not again, please.
Joseph M. Pacella.
Thank you.
Go ahead, Chris.
Good evening, ladies and gentlemen. My name is Christopher King with Atlantic Design Engineers, and we're the engineers of record for the project. As Attorney Pacella had pointed out, we've been through roughly a year process with the site plans being augmented at different phases to address various concerns not only brought up by the conservation but the planning board, abutters, and then also other interests that were identified as important to the town regarding their mission as far as historic preservation.
Excuse me, sir, can I just, when were the final plans submitted that were actually addressed by the decision?
The final plan, the final revision date was September 25th of last year.
And when was the decision?
October 1.
So I just want to say for the record, while there were a year's worth of hearings, the decision came quickly after the plans were finalized?
Sure.
Okay, so I just wanted to say that.
Fair enough.
And I would add to the record as well that I think we were surprised even that we were able to come to an accord with respect to the ceremonial stone issues. I think we all believed, I'm sure, that was going to take a significant amount of additional time. So I think that as much as it caught us off guard, I'm sure it caught everyone off guard, including the public and the board, that happened so quickly. And we asked for a vote that night.
Go ahead.
Sure. So, just to kind of expand a little bit and not belabor some points, with all the information is contained in the packet Attorney Pacella had referenced. But per section 210, 203D, the approval criteria, we feel that the information that was previously submitted demonstrate that the project conforms to the provisions of the article, specifically Article 31, The prescribed setbacks for the solar array facility have been achieved. The commercial Voltaic installation the area that it's located in, the equipment pads being centrally located, and some other design elements. Again, we feel like it will not be detrimental to the neighborhood or the town. In fact, we feel like it would be a benefit to the town, besides the obvious increase in tax benefit. I think some more tangible benefits would be it satisfies the intent of the town being part of the Green Communities Act, bolstering its portfolio and, enabling it or giving it additional power for grant money intended to implement or outsource clean energy solutions in municipal sectors. Also, as I previously mentioned, throughout this process, we were notified that there was a presence of potential ceremonial stones on the property. And we had went and hired the experts, reached out to two tribes, the Narragansett Tribe of Rhode Island and also the akin of Gayhead Wampanoag Tribe of Massachusetts, and worked quite closely with them to develop a sound plan that again went through several revisions and working through all of the terms and making it a win-win not only for the applicant but also for the tribe, and I think in turn for the town, because it's a project that would really highlight the developer, the town, and the tribe's ability to work together to make it a trifecta, a win for all three parties involved. Another approval criteria, the environmental features of the site and the surrounding areas be protected. I feel like that was demonstrated from the fact that we're granted the order of conditions from the Conservation Commission. Again, the plan went through several iterations due to a change in the wetland line, and the project was significantly reduced, not only by losing roughly 1.5 acres of upland area, but also pulling the panels outside of the 100-foot, which, was a request directly from the commission. So with the lot being a challenging shape and not a lot of upland left, we were really stuck to a very limited footprint as far as where we could place panels for that fact alone from the protecting the environmental features. Specifically, areas also would be adequate surface water drainage. And again, this project was reviewed by Phil Paradis of Beta Engineering, and we had addressed all of his concerns. So we've demonstrated that the stormwater as designed will also protect the surrounding environmental features. Per the zoning bylaw section 210-23 special permit criteria, if the board determines that the granting of the special permit will be in harmony with the general purpose and intent of this bylaw. The project is a ground-mounted solar array facility, so we'll need to connect to the electric grid. We've put all of our infrastructure underground, with exception to utility poles that are centrally located, which were required twofold due to the wetland system located on the site that bisects the site, making direct impacts unavoidable unless we go overhead, and then also the fact that the Tennessee gas pipeline also bisects the site in the other direction, and so we needed to adhere not only to the Wetlands Protection Act, the local bylaw, wetland protection bylaw, but also the developer requirements from the Tennessee gas pipeline people. Those poles that are centrally located are over 800 feet from the closest abutter in a central depressed portion of the site. All those things coupled together, we feel, we do understand that per section 210-121.1E, we are requesting a waiver. There is a requirement for a buffer around non-residential uses of 75 feet. We are requesting a waiver in that, and there is a mechanism in the bylaw that allows the board to grant relief from that as long as as long as the applicant rather demonstrates that the remaining buffer is sufficient to screen or separate the use from the adjacent property. And we've revised the plans multiple times to address this as well. Feel like we've addressed individual concerns, and we feel that the remaining buffer is adequate. You know, the relief that we're requesting on the east side of the property, that is not contiguous with the access road, which would be this line here, due to the existing topography, and we are proposing additional alternative screening, rather. And again, the provision in the bylaw, gives the board a mechanism to review alternative screening and site-specific situations, deem that although we don't have 75 feet, the alternative screening in place is sufficient. We have not only alternative screening for 15 Wilson Street, we've proposed a strip of evergreens, which we've worked out the location and the extent of it with the abutter. In addition to that, we've reclaimed some of the existing lawn area in an effort to reforest this portion. And so the skinniest portion, which would be right at the entryway and at the corner here, is 30 feet. But other than those two pinpoint areas along that buffer, the buffer does increase to over the prescribed 75 feet in the middle of that teardrop area. So we feel, again, that particular area is unique because that's where the existing cart path is, that's where the existing break in the stone wall is. And so again, speaking to the scenic nature of Wilson Street, we did everything we could to preserve that entryway. It made the most sense. It's already graded, it's the least amount of land disturbance, it's less tree clearing, and so that's why we're left with the condition along the northerly edge. But again, we feel like our alternative screening is above and beyond and coordinated for, we thought were for individual concerns. In addition to that, on the west side of 15 Wilson Street, we've extended the line down to a point where we feel it would capture all vantage points from that property. And again, the limit of that was coordinated. We feel like we had, come to an amenable solution for the screening for specific to 15 Wilson Street, and that's where we're asking for the waiver for. And the topography as well from 15 Wilson Street down to the site, the closer the panels are, as silly as it sounds, to the bottom of the hill, the less chance you have to see them.
Sorry, you mentioned the waiver. Is that the buffer waiver?
Yes, the buffer waiver for the 75 feet, correct.
And so at the bottom of 15 Wilson Street, what is the?
Here?
Wherever the waiver is that you're talking about.
It's really, we have.
Backyard, no.
We have a small portion here that's over 75 feet, but the remainder of this length is less than the prescribed 75 feet.
So, but 15 Wilson Street is next to where you're.
Correct, right here.
Yes, so that's
yes.
what I'm curious about on the backside.
The backside here?
Yeah.
We have, I believe it's roughly 43 feet to the property line. And when you add in,
As small as 30 feet between the road, the existing cart path and that property.
Correct.
And,
Yep.
and then 43 feet in the back, as small as 43 feet in the back.
Correct. And we do have here where this teardrop comes down and meets this tight corner here, that's 30 feet there.
Yeah.
But it
Yeah.
gets,
I just wanted to make sure I understood.
Sure.
Madam Chair, can I just ask a point of clarity? Going back to the minutes on October 1st, you said that it was as close as 20 feet, and now you're saying 30 feet? I'm just curious if it's 20 or 30.
I just scaled it off before we got in here. It's 30 feet, and that includes the width of the alternative screening. So the 20 feet may have been a reference to including the reforestation, a naturalized forest width, but when you include the width of the actual alternative screening strip, which includes the coniferous plantings, the resulting width is 30 feet.
Okay, thank you.
You're welcome.
And
Yes.
Madam Chairman, as you talked about the alternative screening, could you just go into detail what that alternative screening consists of?
Sure. We've, so we've worked, again, we've taken individual input and we've come up with a landscape screening plan, which has not changed since its last been before you. But the idea was to build in a couple different mechanisms and flexibility, so that, again, the town would have and the abutters would have an opportunity to offer input as far as any kind of species. We reached out, implemented a variety of species that we thought would establish well in the area and also provide the instantaneous screening, because that's what we're looking for. And so, we include a typical planting chart with representative species depending on the different areas. Each area is a little bit unique, but they're all, with exception to outside of jurisdiction, these coniferous or evergreen species, and some of them are native. We've made an effort to create native forest plants, especially in the reforestation areas. We have, as part of the last hearing, there was reference to a landscape performance bond as well as notes and special conditions that would require the project team to go back and, with a representative from the town in the first non-foliar season, reevaluate the alternative screening. So if this was planted in the summer and we think we've covered all holes, you go back when all the leaves fall off and there's a gaping hole, there's, not only is there a condition requiring them to install it, but if for some reason the developer is non-existent, there's also a mechanism for the town to do it, although it's the responsibility of the developer as part of the original approval. So we think that there's a double layer of protection on that. There's a note allowing for substitutions as long as it's approved by the town and approved by our landscape professionals. So we know, if someone likes palm trees, they can't request palm trees be planted if we know they're not going to grow. So we think the alternative screening was well thought out in that respect, and we've really mixed it up and put a diversification of screening, not only per the required 75-foot width with the reforestation and reclaiming some of the lawn, which was a specific request from 15 Wilson Street, but we've also, again, speaking to the scenic nature of Wilson Street, we worked with our wetland scientists, particularly when we get down into the closer to the resource area within jurisdiction, and selected a variety of species that if you drive down Wilson Street, you know that all of the growth, there's hardly any understory. And so the challenge is, what do you do with a regular eye height screening? And so we proposed species that are going to thrive in there, the idea that they're going to reforest and create more of a robust understory, again, protecting the scenic integrity of Wilson Street and abutters across the street. Not to mention, we're well in excess, the 100-foot setback right there ensures we preserve the 75 feet. But along the sideline here, of course, the wetland is there, but we made it a point to, keep the 75 feet. And where we are over the 75 feet, we've still extended a line all the way up. We have over 600 plantings throughout this. Not to mention, at the very last minute before you folks, we made an adjustment here because 21, Mr. Cutter, had a concern about the top of this knob, and he thought that was going to be the thorn in his side if he had to look at that. And so I figured out exactly where it was. We pulled the panels back a little bit to allow for a beefed up row of planting in that area. So although this does not relate to the waiver request for the 75 feet, I think it speaks volumes to the effort that the applicant has allowed us to put forth in an effort to try to address all of concerns brought forth by not only the town, but also the abutters as well.
Madam Chair, thank you.
Yeah, hold on. Okay, I'll look to my left first, because I never look to my left first.
Could you address the fencing that is surrounding the panels and where the wildlife pathways are?
Sure. You brought up a good point related to screening. I forgot to mention that we've also instituted black vinyl all the way from here, all the way around, and again, in an effort to really soften what anyone would perceive as an industrial look And in addition, we've brought all of our infrastructure underground, surrounded it by screening, and are installing an old farm-style fence, not only for an aesthetic added, but also to prevent people from driving down to the entrance fence and doing nefarious things. And again, those were specific requests that we fielded early throughout the process. Speaking to the corridor itself or wildlife, again, this was all reviewed by conservation. We do have a critter gap underneath the fence that will allow the wildlife to migrate. Of course, larger wildlife aren't going to be able to get around that. But again, with the location of the Tennessee gas pipeline, it's not going to take a white-tailed deer a very long time to figure out how to get around the solar facility. Again, it's going to be very limited human activity out there, much less than a residential type use. White-tailed deer are some of the smartest species out there. They used high transmission lines as deer highways anyways. And so, we don't have a break in the array per se, other than at the gas pipeline itself. And that's a fact of where we have a break. It's just another layer of security or locking mechanisms, not only that maintenance would have to go through, but more importantly, emergency response would have to go through if they needed to get from one end of the array to the other. And you start throwing in corridors that each one has a Knox box with a secure access. And so again, we really relied on the professional expertise of Lucas Environmental, who is the conservation's peer reviewer, and the commission itself to identify the design criteria that were most important to protecting the habitat based on their review and evaluation of the project.
Thank you. Also, I was wondering, because I don't recall, and from the plans, I can't really tell, the connection across Wilson Street, is that going to be able to be underground or above ground?
The plans were revised to indicate it be underground.
Okay.
So that, that's the intent. Again, that was, based on feedback and a comment that, DPW would certainly be amenable to that and work through that with us. Ultimately, that's the utility work, but again, if the planning board were to require that, we would certainly follow that condition.
I'm sorry, I was reading too, that's the connection piece you're asking.
The connection across Wilson Street.
Yep.
Yeah. That's also underground.
And that is not part of the original decision, is that correct?
No, I think it was.
I thought so too. Okay, all right.
Yeah, and it's on the September 25th plan set. There's a note there indicating that. So as long as the plan set is referenced, I would think that, but if you wanted to add that in as a written condition.
No, I was hoping that it was, and I'm glad to hear that it is. Okay.
Thank you. I think I'm okay for now.
Okay.
I'm good.
So I just want to make sure I'm clear on the number of waivers. I think maybe Gary asked this. The underground utilities and the buffer, those are both waivers that are being asked for? Are there any others?
Not that I'm aware of.
Okay.
And the undergrounding is central in the site.
Correct.
That'll be overground, right?
So my opinion is I would like not to honor either one of those waivers and come up with a plan that has all the utilities underground. If it means, I understand there's a gas pipeline going through, but if it means having utilities coming from West Wilson Street and also from Hayden Row, then I would like to see that. And secondly, with the buffers, I would like to not supply a waiver for any of those. I'd like them to meet the needs of the zoning.
Can I ask a clarifying question on that piece? Because I see that buffer question as being for me, a little complicated because of using the existing cart path as being an attractive feature of accommodating the scenic road. So
It's my opinion that I feel that with a project this size that they should be able to meet the buffers.
Okay.
Can I ask a quick, could you show where the utilities would be above ground? It's just in the center of the site, I believe.
So the utilities above ground are limited to poles that, where we cross the easement, because we can't go underground with the gas pipeline, and then also where we cross the wetland and then back over the easement.
And there are already utilities above ground at that location, right? That's all along the,
No, it's
Or
just
no?
an underground gas line there.
Oh, it's just
so
the gas
there are
line.
there are no above-ground utilities.
Okay, so was the one at the wetlands at the request of the Concom?
Yes,
And then the ones across the pipeline are at the request of Tennessee Gas?
correct. There's only, they have a set of developer guidelines which dictate what you can and cannot do within their easement and within a certain proximity, depending on the activity. And so we, again, went and tried to really maximize our spans and limit the amount of poles that were above ground, but due to the location of the easement and then the bisecting wetland, it forced our hand to have 4 poles, I believe, above ground.
And that's where the waiver's coming from, that's where waiver's coming from.
5 poles, excuse me.
5 poles.
5 poles in total above ground.
Go ahead, Amy, I'm sorry, I kind of
sorry, so
hijacked your
I would
question.
lean towards allowing the waiver for the above-ground utilities, because I don't think they can be seen from the residences, but I'd like to hear from the abutters on that.
Yeah, we are definitely going to hear from the abutters.
And speaking to that as well, again, I'd be remiss if I didn't mention, this is over 800 feet from here back to this easement area. In addition, these poles are going to be a standard utility pole. And so the existing vegetation that's going to remain is going to, it's all associated with the wetland here. And this isn't an open marsh meadow wetland, it's a wooded wetland. And so the existing vegetation that's going to remain is going to be a lot higher than the poles that are going to be installed, and that alone is going to make it so these things are not even going to be visible from the Wilson Street side. A project, the viability of a project is based on its interconnection agreement, and it's a contractual obligation with the utility that took 2 years in the process before we even submitted an application to the town of Hopkinton. And the idea of splitting this into potentially 2 points of interconnection, the size of this here, and understanding the terms and the hurdles we have to come to an agreement with a final design during construction with the tribes would really make this not feasible. And collectively as a whole, the project is one of the smaller ones that we've permitted with TJA. And due to some of the factors that I've already discussed, the available upland where we can actually site these panels is extremely limited and challenging, not only due to that, but also the site topography as well.
Did you have any more? Okay, Darren.
Good.
Ben?
I think I concur with David. I have some concerns about the privacy of the screening and the locations, and the location actually of the drawn cart path. I drove by there today, and I have some photographs. I didn't have time to submit them. But the opening in the woods was in a different angle than it's shown on the plan. And so I'd like that to be looked at. It looked from the road to be perpendicular, not at a 45 degree. So I would like to offer that as a suggestion, if we could take a look at the accuracy of the original plan to make sure that that cart path is actually in its proper location.
I mean, just speaking to, I guess, the location of the cart path, everything was surveyed out there. It's a cart path that hasn't been traveled in years, so we'll typically pick up the center line and run that survey down and then show a representative tree line. I'm confident in the accuracy of where the cart path is shown. In addition, there is a note on the plan. And again, the idea here is that wherever the cart path is, that's where we intend the entrance to be. Again, we intend on not disturbing the existing stone wall. There's plenty of width in there to accommodate the entrance we'd be looking for. And so, there's a note on the plan specifically calling out the requirement for additional approval if we plan on disturbing the stone wall. But, I would, guarantee that if a field adjustment had to be made to miss it, that would, be made. But the width and the location of it, particularly at the entrance, I'm confident in the accuracy of that. I know that we have survey points all the way down that path, all the way to the easement.
And confident that it would not impose closer than your 30 feet at the closest point for your buffer? It wouldn't squeeze that?
Yeah, I'm confident in that, and, if that would be, something that would need to be memorialized, we could certainly, cite that specific dimension there. But based on, the width of the road and the width of the existing cut and the location of it,
To the chair.
the distance to the edge of the cart path, I'm confident would be 30 feet. Is there a tree right on the edge of it? There's not a set line of trees exactly, along that cart path. They all stagger. But the idea is that the edge of that cart path, where it comes out onto Wilson Street, the distance from the edge of the cart path, or our tree clearing required for our access, would leave 30 feet to that property corner.
So in my completing my statement, I feel that without providing for the waiver, that they can do it within the required setbacks. They can provide for their access to their facility within required setbacks without having to make modifications.
Can I ask how that would work? I don't know, I'm not sure I understand you.
Well, what it would require would be setting the cart path, shifting the cart path, shifting the access over and creating a slightly different angled access. If this is correct, which I am sort of challenging because of what I saw, but what it would do would be shift the access slightly 30 degrees at that entrance, so it's not so obtrusive into the lawn of the Shambos.
You can, but can I come back? It's just so we get around, everybody definitely hold on to your question.
So it would be to shift the cart path so it's not as obtrusive in concurrence with.
So it doesn't impose on the buffer?
So it doesn't impose on, right.
The buffer is
The buffer.
maintained?
Okay.
Yes, thank you. A couple questions, a couple comments. First of all, is there any new information being presented today that wasn't presented before?
No.
So I'm a little confused by Mr. Cutter not being aware of some of the plantings and things that you were talking about today that he didn't know about earlier. So I'm a little concerned that maybe there's not been enough communication with the abutters, and I would just like to see a better job of that going forward. Second of all, I'm not entirely clear why the interconnection cannot be on Cedar Street, which is a commercial zone, as opposed to being on Wilson Street, which is a residential zone and a scenic roadway. I would like to have a better understanding of that, voting or non-voting, but I think that should be discussed here tonight, especially with the abutters here. I think that was, from my understanding, as an observer on tape of what happened on the vote, was that really wasn't addressed. And when I was here, and I've asked this before, I don't think it's really been addressed directly. So if you could explain in black and white layman terms why the interconnect has to be on Wilson Street, or why it cannot be on Cedar Street. Either way, I'd like to understand that.
I'll speak to the landscape screening. There is no new information being presented tonight. Mr. Cutter, before we submitted the last plan set on September 25th, if you like, I didn't print them out, but I have emails back and forth with Mr. Cutter with the PDF plans, making the last-minute adjustment that I referenced when I was standing up at the board, increasing the buffer.
That wasn't a last-minute adjustment for today, it was a last-minute adjustment.
No, it was last-minute adjustment prior to September 25th. So again...
I get that.
Frank,
Sure.
let him finish.
And then, as far as the interconnection, I'll let Attorney Pacella speak to that.
So we've, first and foremost on the landscaping issue, I think we've done a very good job of meeting with the abutters. We've in fact met with them numerous times. The developer himself, our engineer, we've talked after prior meetings. At many points, we've been, our absolute understanding was that we had satisfied concerns, and then afterwards, the ball was kicked a little further. We made further changes to satisfy more the same concerns by increasing the buffer. And so I think we've done a very good job of making the information available, addressing their concerns. I would note that in the prior decision, that was the special conditions, we were amenable and certainly, I believe, suggestive of the concurrent planting, the fact that a wetland scientist or a landscape architect will meet with the homeowners individually. And I'm talking about the conditions 1, 2, 3, 4, and 20 and 23, and that we would, prior to planting, that we would be required to maximize the screening effectiveness of the ensure the successful establishment of the plantings. That on number 4, following planting, the effectiveness of the installed screening will be reevaluated during the non-foliar season by a qualified scientist. So not only the expense, but the follow-through, those are all issues of agreement on our part to make sure that that screening it complies with the bylaw to effectively screen away any concern that they would have. With respect, there's no topography issue that places this property, the panels at a position where they can't be screened effectively. Moreover, we're required to maintain it in good condition. We're required also to post a $10,000 bond. Frankly, if the town wishes to increase that figure to anything up to $20,000, I think the developer would have no problem with that to ensure that the screening is not going to be an issue. And that's to, and again, with respect to the issue of the interconnection, just to highlight it very quickly, that is something that was determined by the utility early on. The real rub is the fact that the bylaws do not require that we put the interconnection one place or another. There's nothing in the bylaws that require that we do that. What the bylaws require is the underground utilities, and that was the issue that had surfaced because it was coming out on Wilson, and people were seeing the above-ground utilities, which frankly I think was our mistake. I think the developer hadn't realized that nuance in these bylaws, which protect individuals by requiring that they be underground, that other towns don't have, and immediately we addressed it. So that was the issue, is the fact that it can be seen. And now that it's underground, that the connection across the street's underground, that's really, from our perspective, a non-issue. It's something that you can't validly force us to do. And secondarily, we went through this whole process of showing why that would be financially impossible for us, why it would be difficult, why it was, I think the developer even paid an exorbitant fee to resubmit to see if there would be problems with it, and it was immediately red flagged. There's a greater ability to, the utility decides on a site like this, which has more than one location to interconnect, which would be better for the utility, and that would mean which line is better suited to taking on the new electricity. And we started with that up front. It wasn't anything we chose, and the issue, again, that surfaced was the fact that the interconnection would be seen, and now it will not be. And so I believe we've completely addressed that issue.
Through the chair, can I address the point that he just made?
You can.
Thank you. So you had mentioned that the bylaw doesn't specify where it should come in, but I would question that because indirectly it does, because there's the gas pipeline running through the middle, and we have all utilities underground bylaws, so therefore it does affect where it comes in from indirectly, in my opinion.
I'm talking about legally. I don't believe the land court will find that we're required by this bylaw to move our interconnection from from Wilson Street to Cedar Street.
I would agree with that. I was just saying, but in order to satisfy the underground utilities requirement, you might have to come in from both sides.
Both sides, right.
Yes.
Right, I understand what you're saying. Because again, you're talking having to subvert or deal with Tennessee Gas is an impossibility from our perspective. It's an impossibility.
Sure.
The risk, to everyone involved, life and property, is why they require that you do not go underground a major gas line that if disturbed would shut off many consumers. So at worst, you'd have two different connections, which wouldn't resolve the one connection that we have. And what we've proposed, I think, will be less of a disturbance to have the one connection rather than two, as you had suggested.
I'm going to get to Carol first.
I'm going to let all the voting members ask their questions first.
Okay, go ahead, Gary.
Two comments and a question. One, I just want to say that I agree with you, and I commend you guys for working as much as you have with the abutters, because I think that came through throughout the process, and I always appreciate it when developers are talking directly to abutters instead of always going through us, so it's just my opinion. Secondly, I know that you keep referring to the financial viability of the project. Personally, for me as a planning board member, I don't really care about the financial viability. So to me, that's not an argument either way. I realize it's important to you, but to me as a planning board member, that's not a concern. Question for you. So just hypothetically speaking, if you had to conform to the buffer requirement, then I'm assuming that would mean that you'd have to get rid of some panels, you'd have to move the cart path. If you were to have to do that, can you just hypothetically speak through what changes would have to be made to comply with that 75-foot buffer?
So just first in addressing what you stated, it's our position that under 48 Section 3, solar cannot be unreasonably restricted, and as the response from, I believe it's the Attorney General's office to the bylaw, it's not the bylaw in and of itself as written, it complies, but it can't be used to unreasonably restrict solar. And so it would be our position that requiring us to have something that cannot financially be done would unreasonably restrict solar. So that is what we believe the law is on this. And so by reducing the amount of panels further than have already been reduced, by requiring other items, that it's our belief that will be an unreasonable restriction on solar under Section 3. This is a 2.5 megawatt project. Getting into that piece, because that's a very critical piece legally with the land court especially, is that there are interconnection costs based on upgrades that have to be paid in order to pursue a project, among many other costs. And the viability is very easily determined up front with respect to looking at how many megawatts you need to be able to make those payments. Yep. Is kind of the issue, and so it's our position that legally that's a valid and very germane point, in that if we're restricted in a way that makes it financially unreasonable, then we would submit that it's a violation of Section 3.
Understand. So back to the question though, if you were to comply with that 75-foot buffer requirement, then what would have to change and how many panels would you lose?
Well, the landscaping plan would change dramatically.
I
because-
understand. Just, if you can just answer that question. as
Can you
to
just show where the
how many
75-foot line
panels
would-
you would lose?
You want to know
if
where the
you had to
75-foot
apply
line would be?
75 feet.
So we would lose a portion of this section of the array here to maintain the 75 feet from the property line. I'm not sure an exact panel count. Probably 200 panels in this area, maybe. I think the most significant change and the most challenging change would be up around the Wilson Street area. We would obviously have to realign our entry, disturb the existing stone wall, and then grade in a new access road along this side slope here where it gets a little bit, it gets pretty steep as you come down towards the resource area. And that would, you know, again, and not being able to look at it instantaneously from a stormwater standpoint, it certainly would, you know, push the road in through this finger of the array, if you will, and more than likely, the remaining panels within that probably are not feasible due to the proximity to the resource area. And so we would lose a significant number of panels in this area, probably, I don't know, somewhere in the neighborhood of 500 to 1,000, something.
What's the total number of arrays?
The total number of panels. I think I may have taken it off. I think I had taken it off.
Roughly, do you have a rough idea? Roughly percentage-wise, or?
I'll say 2,000. I could back calc it out pretty quickly. The reason why we took the number of panels off for this project at least is, you know, we're looking at this as a footprint. Every contractor approaches every site differently, particularly a site that you need to do some tree clearing. So they'll do their tree clearing, they come out and they'll do a more specific shade study. They have a preliminary shade study, but without having the on-site and the actual open area available, they don't have the specific information. So they'll do it and they'll work within that footprint. And so sometimes they may stand here with a helioscope and determine that, you know what, we don't want to tuck panels up here, they're not gonna run efficiently, and so they may pull it back themselves. So, you know, so again, it's the number of panels, and again, some of the challenges down here and in this area, we show for graphic purposes a footprint. And within that footprint, we have a conservative estimate of the number of panels, but ultimately it's up to the contractor to decide exactly how many panels and exactly where they go within the footprint and the restrictions that are put in place.
Just for approximation purposes, if you had to comply with that 75-foot buffer zone, approximately what percentage of your panels would you lose?
Panels will we lose?
Just, you know, you can give a range, ballpark. I realize.
Maybe like 10%?
10%?
That's kind of was rough cutting as I was
Probably
looking at.
10%, I would guess.
Through the chair, may I ask a follow-on question?
Yep, hold on. Did you have something?
I do.
Yeah.
I'll just be brief, but I'm concerned with the panels that are near Wilson Street, but I don't think I would want to see the cart path moved because then they would have to disturb the scenic road trees and the walls, and I don't think the cart path is really very disruptive to the neighbors. So
It's existing too, they're not.
it's existing too, but I think it's better than making a new driveway. So I just wanted to add that.
So I just want to say that I have sort of not been saying anything, but that is one of my biggest rub points are the panels there. And I think that I would personally feel like I would accommodate the waiver on that side and leave the cart path alone for a lot of reasons. One, that it exists and it doesn't disturb the scenic road, but in a trade-off for that segment of panels, I do worry, even with the screening, that does disrupt the scenic road appearance. And I know that it's not necessarily our scenic road bylaw impact, but the viewscape and the gap in the trees makes a big difference. Just, I want to say that.
So just to follow on to something Gary said and what Deb said as well about the buffer areas, I just wanted to be clear. So we're talking about that whole section there, but did you also mention that there was another buffer waiver up top on?
No, I was pointing out that we're providing alternative screening in other areas
Okay.
where we're not, required to say increase the buffer or even provide alternative screening, in an effort to really.
Okay, so it would just be in that one area we're talking about there?
Correct.
Thank you.
Yeah, the L shape, if you will.
Thank you.
Okay, so I want to just remind people that we are going to be making a decision on the special permit, and we have to determine each of the following, and I'm going to read it out, and then I'm going to open it up for public comment. The commercial solar photovoltaic installation conforms to the provisions of the article. The commercial solar photovoltaic installation will not be detrimental to the neighborhood or the town. The environmental features of this site and surrounding areas are protected, and specifically surrounding areas will be protected from the proposed use by the provision of adequate surface water drainage. Massachusetts general law, I'm trying to capture the biggest points that we have to consider. Says that no zoning ordinance or bylaw shall prohibit or unreasonably regulate the installation of solar energy systems or the building of structures that facilitate the collection of solar energy except where necessary to protect the public health, safety, or welfare. And I think we have captured the major topics of discussion detailed out in the decision and what was in our documents. The screening of the solar facility from the adjacent properties was one. The visual impacts of the proposed project was one. The point of interconnection to the electric grid was one, and the site access and preservation of the site ceremonial stone landscapes. I also want to make sure that everybody understands that we have to leave here by 10. So we may or may not seal the deal tonight, because we do have to hear from the public and then have an opportunity to sort of mull it through. So those are our parameters.
Question on the
Nope.
process?
Yeah?
So I just wanted to point out that if we do approve it tonight, it sounds like we'd be able to finish it up tonight, but if we,
Vote. I didn't mean.
but if we vote to not approve it, we have to come up with all the findings, and that's going to take some time. I just want to make that point.
Yeah, so the vote has to include the findings, whether we approve it or disapprove it,
Okay, so we're going to spend time
on the findings.
after the vote.
I would submit that the process is before the vote for the findings of fact.
Okay. My also question about, before we get to the point of vote, I would like to see a listing of the findings in front of me. We don't have them in our, not the findings, but the
Conditions?
the provisions, additional provisions. We don't, I would like to see it in front of us, going off of
I'm
memory
sorry,
and all this stuff.
I'm only looking at you with this blank stare because I'm not sure I understand.
I just want something in front of me, either on the
Additional
screen
Or the existing conditions.
the existing conditions that we voted on last time, if we're going to be voting again.
Yes, all right. Well, we had those in our packet.
They're in the packet.
I didn't see them. What page are they on?
They're not in your packet.
There was a link to the in the
board's
packet.
decision, but I will provide you a copy if it gets to that.
Okay, thank you.
Yeah. We have.
Yeah, we had a link to that.
Okay.
Yeah.
If you can, thank you.
Okay, so are you amenable to us, we're going to open it up to public comment, okay? So, I anticipate that there will be public comment. So who would like to come forward first? Come on ahead, Tom. Remember to just, we're very familiar with who you are, but please remember to introduce yourself.
I don't know if that's a good thing or a bad thing.
That's a good thing. It's always a good thing.
My name is Tom Shambo. I live at 15 Wilson Street, one of the abutters to the proposed project. I have been in front of the Conservation Commission or the Planning Board since around 2004, 2005. There have been 3 projects proposed for this property over that time. I appreciate that I have the opportunity to speak with you all here, and I thank you all for the openness in which you're allowing us to communicate. It's been a pleasurable process, this far. There are so many things that I'd like to say, but I'm going to try to keep it brief. I had mentioned before that two other projects have been proposed. I have a map from 2005. Same landowner, different engineer. It shows a whole set of wetlands down on the southern part, right behind my property.
So can I ask you, and I'm sure this is purposeful, Tom, we've known each other a long time, but I think it's more pertinent if we stick to the project here, and just speaking for myself, I'm going to trust that the Concom did the appropriate delineations on the wetlands on the site.
I was just trying to point out that the wetlands had been noted here, 2008.
Yep.
But when the first project was proposed and about another 1,000 panels were put in place, all of a sudden those wetlands had disappeared.
Okay.
I can appreciate the fact that they think that they lost those panels, but I don't think they were even supposed to be there to begin with. It's been wetlands for a long time.
Okay.
So that's my point number one.
Yep, thank you.
My other point, I had reached out to Chris during the Concom pieces, and I invited them to our property to have a meeting with the abutters. So I think it's been going both ways, that we've tried to communicate, tried to have a good discussion, conversation, even let them on my property to do some of the surveying. Not an issue. Haven't really tried to stop this project. But I have articulated my 5 points since the beginning. And I'm not sure that they've really been addressed. I would like to maintain my 75-foot buffer. If you've gone over to Alexander Street and you've seen the Lumber Street project, those panels are about 200-plus feet away from the house, and it looks like they're right in their backyard. I'm asking for 75. I have a swimming pool back there on the side of my property. I have been mowing that lawn for 20-some years. It's been my water that's been watering it. It's been my fertilizer that's been fertilizing it. There was an agreement with the Murphys who owned it before DePietri, and DePietri assumed it, and we had a conversation about it. So I've been trespassing, I guess, on the property. I was even given permission to go out the cart path all the way to the pipeline to take children on hay rides.
Tom, to be clear, you're talking about the back part of your property. Do you have an issue with the cart path?
I would like 75 feet maintained on my property on both the northern and the western side. I am willing to talk about maybe if some panels were removed between Mr. Cutter and myself on 21 and 15 Wilson Street, that the buffer in the back maybe, is okay. But I would like to ask that you maintain that 75 feet.
Through the chair, can I ask a question to Mr. Shambo?
Sure.
So, I'm just curious, because I do think that they have offered up substantially more plantings for that smaller buffer zone. And I'm going to make an assumption here, maybe that's right or wrong, but if they had to comply with that 75-foot buffer, then they're going to revert back to the minimum amount of plantings and fencing and whatever else. And to your point, 200 feet with fairly thin plantings doesn't do a whole lot. So I'm just curious for you, if you have a preference of having the smaller buffer zone with substantially more screening, or if you'd rather have that additional footage and lose all of the additional plantings and screenings that they've offered.
Yeah, so that's a great question, and I don't know if you're referring to the northern side or the western side?
Both.
Okay, so on the northern side, there's 75 feet in the middle, and I don't believe it's 30 feet, maybe 20 feet by the road, and maybe another 20, 30 feet on the back side where the cart path is, that natural growth can occur. I think they have to do, I would hope that they would do some level of screening. On the back side of the property, and to some degree on the western side of the property, it's on my property that the plantings are occurring. Because the topography or whatever, I'm not an architect, I'm not a landscaper, I don't know why.
A segment of the planting, sure.
Yeah. So I have been trying to work, to make that, happen. But 75 or 80 feet, whatever it is, from Wilson Street with those panels between 21 and 15, I don't think you can put enough screening up to actually hide them or make them non-visible.
Yeah, I'm just saying that if they were to conform to the bylaw, though, they could go 75 feet, and maybe they might lose a few panels, but you're going to potentially have many, many fewer plantings.
But it's on my property, so I can plant the trees myself.
On the backside, okay.
I've contacted a fence person. I'm looking at what it's going to cost me to do some of those things already.
So, side note, if you're putting fertilizer down within 100 foot of the buffer or the wetlands, maybe that's something you shouldn't be doing.
Yeah, I don't think I've been putting fertilizer down within 100 foot of any wetlands. My
That
property
you're mowing
goes to
the
the
lawn
car
where they're
path.
planting is
So
going to be.
we're going to stay in our lane, Frank.
Sure.
I'd like to see the interconnection on Cedar Street. I'd like to see year-round screening as opposed to deciduous screening. I'd like to maintain the integrity of the scenic road, and I think, the underground connection in the middle of the array, again, if you go over to Alexander Road and you see how far you can see once the trees are cut, you will see those telephone poles. You will see all the way to the end of those panels from Wilson Street. There's no question in my mind that that's going to happen. And so if we're going to allow that to happen and the telephone poles to be there, I'd like to have my buffer maintained, and those are my 5 conditions. I think that's primarily what I wanted to say.
So I appreciate it, Tom. Will you just quickly repeat your 5 in short term?
Section 210-201G, underground connections within the array.
Yep,
Large animal gate,
yep,
which was also asked for, and I think Lumber
Yep,
Street actually
yep.
put it in. 75 feet to be held for my buffer.
yep,
Interconnection on Cedar Street versus Wilson Street,
yep.
and year-round screening.
Very concise.
Thank you. Thank you.
Okay. Who's next? Come on up. Definitely introduce yourself again, Mr. Cutter.
I'm sorry, I didn't hear that well.
Definitely introduce yourself each time you come up.
I know that. I'm okay the second time each time. There's a lot of things here, I'll try not to take all night. We should never forget that this is putting 6,600 panels in the midst of a residential neighborhood that's on scenic road. You can talk about screening till the cows come home, but the fact is that there will be detriment to the neighborhood. It just can't be avoided. I believe that the applicant has made some good efforts to provide screening. Not all that I would have liked, but they made some good moves here. But it's not going to do the total job. And the words in the solar bylaw will not cause detriment to the neighborhood. I believe that the present proposal will cause detriment to the neighborhood. It's hard for people maybe to wrap around that because it's really visual, but it's how you feel when you go out each morning. You come home at night and you see a whole bunch of panels. I used to have a nice area here. I've been there since 2000. This is the longest I've lived in any house. And we picked this house because what it had. I mean, it had quality of life and sort of a country back road. And I worry that that's going to be wiped out. Interconnecting with and highlighting other possible violations, the proposed installation does not satisfy the opening paragraph, I think, of the solar bylaw to minimize impacts on residential neighborhoods. Despite a suggestion, or at least somebody raised the issue in the planning board, the applicant has refused to remove the 2 rows of panels that are between my lot at 21 and Tom's. No matter what screening efforts to talk about, they won't totally hide the panels. And these are so close to the street, maybe somebody can correct me, I think it's maybe 75 feet, that when you ride by, you're going to see them. And Susan Hanowich is going to see them from the top of her driveway. Missy, who's here, is going to see it when she drives out. Matt's going to see it. I could name more people. Chad, up the street, higher, he's going to see that. So here's something, at the October hearing, the applicant stated as a basis for refusal that, I got a quote, this site was one of the smaller projects in its portfolio. I can only get so sympathetic with that. because I balance against that how I live and how I feel about what I live. I think that on any balancing of equities, preservation should be, first of all, the quality of life, and that should not be sacrificed for financial gain of the applicant. The applicant was required at the Conservation Commission to cut back on its number of panels, first of all, because it had overstated what wasn't wetlands. Yes, overstated what wasn't. And then there was I think I had it right, then a setback requirement. There was a threat that it would kill the project, but it didn't. In fact, it found a way to add another 200 panels, and I'm not knocking they're doing this, but it just shows that they could do it in the southwest corner array. I believe that the applicant should have offered to remove these 2 rows without being asked to. With respect to the connection on Cedar Street, it's been talked about, bandied back and forth. I'm still not sure what the whole story is. All I know is that well, not all that I know, but at the hearing on October 1st, there were questions put to the applicant, and they said, well, we don't know what fatal flaw means. And there was a mention today, I think, that, it could be so financially intolerable, what it might be to do it. I haven't heard a number yet. That's the obvious place. As Tom mentioned, in 2008, I think he did mention, but it's true even if he didn't mention it, the back of the site that which borders on Cedar Street, there was a zoning change, and 10 acres became industrial. That was sort of a trade-off at that point between the abutters, who had been told that there would be some residential development on, in fact, a 7 to 8 single-family house subdivision on Wilson Street. The bylaw is a requirement that the special permit will be in harmony with the general purpose of the zoning bylaw. I think a basic principle of zoning is to provide, especially to residents, people in residential areas, that enjoyment of their residence and neighborhood will not be unreasonably denigrated for purposes financial gain of others. Most of the residents in this neighborhood, Tom, Matt's people have been here for 100 years, I think, myself, we've been here. We picked this space and we wanted to live in the type of space that we picked. The owner of the site, he had no reason to expect he was going to have a solar farm, because the solar farm provision wasn't adopted until 2014. If the special permit is denied, the owner will not be deprived of anything he had any right to expect when he invested. But if it is granted, the residential neighbors would suffer loss of the benefits that had caused them to invest, to live, and to be on Wilson Street.
Mrs. Chairman, this is the second time through, and we're really going late. I don't mean to cut you off.
I actually am watching the clock, thank you. I want Mr. Cutter to finish.
I'll try to go a little bit faster.
So you do have like 2 minutes.
Okay,
Unless
I would
you-
then like to emphasize what I think, to me, is the most important point, and it really impacts others more than me, not that I'm a good citizen, trust me. And that's the 2 rows of panels between Tom and me. I think that kills Tom's property. It's not so bad for me because I'm backed away from it a bit, but for the people on the other side of the street, when they come by, they go up their driveways, they come out of their driveways, they're looking from the top of the hill. Chad Klasner, if I got that right, was here last time. Stan, who lives down the street, talked about it, how bad, other things he had looked at. I looked at Alexander, and even with the snow covering, it was pretty terrible. So And it sounded like that might be a way to also adjust at the same time the buffering issue. And that was discussed at the last meeting. It's still been rejected. I would hope that the board would think about that some more, and so would the applicant. That takes a lot of the curse off this whole project for a lot of people. I thank you for your consideration.
Thank you. I'm pretty aware that more people might want to speak. We are out of time, so we will start with public comment when we continue this, okay?
In that case, I do have some questions for Mr. Carter.
You're going to have to wait, actually. So I would like to ask this board if they are willing to meet at 6:30 or 7 on March 25th for an extended meeting to get this taken care of.
There's no way I can get here any time like that.
You can't vote.
But I think I should participate in this process, and I would also like to ask Ray, I stayed with him after our last meeting. I am 95% certain that I can vote, as well as Carol, but I do want to be part of this process, and I think meeting, for those of us who work in Boston, we're on the train, it's...
What time is the earliest you can get here?
7.
So I would like to entertain starting at 7 and...
Thank you.
Hold up, okay?
Thank you.
I am very happy for you, through Elaine, to ask town council for clarification on that issue. I'm less happy to keep addressing it here in this public hearing. Okay, so get your answer and find out. All right, so I will entertain, so I want to say a couple of things. So I'm going to entertain a motion to continue this public hearing to 7 o'clock on March 25th. But I want to make sure that everybody understands, the applicant and the public, that the number of votes needed is six, and we believe, 7 members voting. Okay, so that's important for the applicant to understand in this process, as well as the public. The other thing I want to make sure I say tonight is that in the judicial process is not the place to resolve your differences and negotiate your positions, all right? The public hearing process in front of the planning board is the best place to get the accommodations that you most need in the balance of property rights, development, that which is allowed, whether we like it or not, in a residential area. And if it goes forward, I mean, if worst case scenario, if it goes forward and it is decided in the judicial process, the negotiations and the conditions that we have settled upon can be lost. I just want everybody thinking about that as we come back on March 25th. The time to capitalize on your negotiation positioning and your ability to work with each other to come to some amenable agreement is in this process. You're best served in this process, typically, not the courts. So I will entertain a motion to continue the public hearing to March 25th at 7 p.m. That's an early start for us.
So moved. Second.
All those in favor?
Discussion?
Yes.
I just want to make a point that I'd
Yep.
prefer to meet at 7:30. I think we go through a lot of stuff in this board in 2.5, 3 hours, so I'd like to stick to the schedule.
Okay.
If there's only a half an hour for this discussion at that March 25th meeting, I don't think we're going to, get very far. So,
we have...
Public hearing at 7:30?
There is a public hearing at 7:30, and part of our process, I don't disagree, but part of our process is that we can push things forward, and we do have Maspinock that is continuously continued. So we potentially have a gap of time to utilize, which I would like to take advantage of in the interest of expediency if it works out. But I understand that it might not.
Okay. Or is a special meeting an option?
Is a special meeting an option?
Certainly an option for me. from
I
my
think that,
perspective.
I'd be in favor of that. I think there's enough here that we need to talk about.
So we typically meet on Mondays, but is Monday the opposite Monday, the ZAC meeting?
I just wanted to say that I'm going to be away the next week, and I plan my vacation according to our schedule.
Thank you.
Fair enough.
It is fair enough.
One other option is that we, and I know this doesn't work for Frank, but we move it forward to 6:30, which gives us a full hour. I mean, I don't know if people have a preference of a special meeting or we just start earlier. Makes for a long night, but.
So my preference is to start at 6:30, but
I could also offer up April Fool's Day for a zoning advisory committee meeting. We could cancel that meeting. So it wouldn't be our next ZAC meeting, it would be the following ZAC meeting.
that you would.
That I would
move
cancel in favor of a special meeting.
On the 1st.
On the 1st.
Yes, yes.
What day?
Yeah, I understand.
April 1st.
April 1st.
My preference would be 6:30 start on the 25th.
All right, so what's your preference?
April 1st, but I can do 6:30 on the 25th.
Thank you.
I can do either one.
Either one. I can do either one. My preference is 6:30.
Same for me. Either one, but I prefer 6:30.
I don't have a preference.
Okay.
6:30 is my preference on the 25th.
Either one, 6:30 preference.
Okay.
April 1st, I could do at 7:30-ish.
You're gonna just roll. I like it.
I'm.
You might even
I've
come
got
late,
plans
right?
April 1st anyway, so.
All right. I'm gonna entertain a motion to continue the public hearing to 6:30 on, March 25th.
Well, wait a minute.
Hold on, Frank, I am still speaking. The caveat being that if Frank were to find out that he is able to vote, we will have to wait to start until he is able to be here at 7.
Fair enough.
Yes.
Don't we have to have a definitive time?
Yep, so we're gonna meet at 6:30 and whistle a happy tune and do other business.
Okay.
If in fact Frank is able to vote and we're waiting for him at 7, that's only fair.
But regardless, my name's on this, I'm an elected member of this board. If I can vote on this issue or not, I am part of the discussion, and if I've missed 2 meetings because of my busy personal life, and if you move a meeting that I cannot get to, then that rubs me the wrong way, because my name's on this legal form. My name's getting legal form sent to my house at Christmas time, which I couldn't get.
gonna say it got sent
I feel the stress and the pressure of the situation, and I want to be a part of the solution, and I don't want to be cut out of it if we're meeting at 6:30, which is undoable for me.
Okay, so.
I do appreciate the fact that it's only a half hour, and if your solution fits, thank you.
Okay, yeah. I appreciate your investment, I really do. It's been moved for 6:30. I'll entertain a motion for the 6:30 with the caveat that we will have to wait for 7 if Frank is in fact able to vote.
Second.
Is there further discussion? All those in favor signify by saying aye. Aye. Any opposed?
Nay.
Aye.
Yep, 2.
I voted yes.
You voted yes, okay.
Sorry, who said nay?
Dave? Yeah, all right. Okay, so 6:30, March 25th, we will start with public comment because I recognize we did not get to everybody who may have come and wanted to speak, okay? Thank you very much. We should do that last A&R plan for sure. Mhm. So,
Thanks, Chris.
is there any discussion or questions on that one? I'll entertain a motion to approve that A&R plan for Legacy Farms North.
I'll make a motion.
Is there a second?
Second?
Is there any further discussion? All those in favor signify by saying aye. Aye. Any opposed? Any abstentions? Okay. And then 2 signatures? On the way out. Yes. I will entertain a motion to adjourn. That's the word I was looking for. I'm very tired.
So moved. Second.
All those in favor? Aye. I should have said this before, but there was one item that we didn't get to. Everybody should put their thinking caps on to think about how they want to support that.
The trail.
But we can't talk about it.
Yeah.